Welcome everybody to today's webinar. Our host today is Alton Perry. Alton, I'm going to turn it over to you.
Thank you, Bob. Thank you everyone for joining us today for our second session of our webinar on estate planning and heirs property. Great to have you again. Those of you who were with us last evening, great to have you back today. And those who are just coming with us today, great to have you joining us today. Again, we're going to have some great information being provided to you through partners of ours from the Conservation Fund, Margaret Conrad and Peg Coring. Just a few housekeeping rules. If you have a question, you can place that question in the Q&A. There's a little Q&A symbol there on your screen. If you don't put it in the Q&A and you put it in the chat, that's okay too, but we'll get to it. I will also add that we may not get to every question, but there will be an opportunity for follow-up after the session. We'll have the contact information for the presenters today as well. Also, there is a survey at the end of the session that we greatly would appreciate it if you would take a minute just to complete that, to give us some information that help us improve on what we're doing and providing you the services and programs that you need. Also, there will be an opportunity at the end to have a Q&A. We're actually going to have all of our presenters present at the end. The two presenters from last night, Ms. Mavis Craig and also Pamela Harrigan Young, who spoke on the estate planning and wills, that type of thing. So they'll be joining us along with Peg and Margaret to answer all of your questions in the Q&A session at the end. If there is anyone who is calling in today, if you will like a copy of the presentation, please let us know, contact us, and we'll have our contact information up as well. And also we'll include it in the chat for those who are online as well. So I think that covers all of my housekeeping for today. And so let's, without further ado, get to our first presentation. And that's going to be you, Peg? Okay, well, I will turn it over to you.
All right, thank you so much. Hi, I'm Peg Coring. As you can tell from my accent, I am not from North Carolina. I'm a grape farmer from Michigan. I'll start the presentation, and then Margaret Conrad will end up the presentation. So we'll look forward to being with you and talking with you. I am assuming that my screen is showing so that it's live. All right, so I'm on the right, Margaret's on the left there. So we're a team from the Conservation Fund. I was wondering to begin with if you would use your chats and tell me if you know what type of deed you have. So at the top of the deed for your property, your land, I know some of you don't own land. I was looking through your kind of checklist. Thank you for doing that. But do any of you know what type of deed you have? Just put it in the chat and we'll pick it up and see if you know. Okay, we have some coming in. So we have general warranty, that's good. Someone doesn't know, a gift deed, okay. Anybody else? All right, well, that's something you ought to know if you don't know it. So you need to pull that deed and take a look. So these are some of the common deeds. We'll talk about gift deeds under the quitclaim deed. Let's see, I am having trouble advancing my screen. There we go. So the general warranty deed is the best type of deed to have. There was one of you had a general warranty deed. And that means the previous landowner and the previous landowners say, I didn't do anything to mess up this title for this deed. There are no existing loans. There's been no work, they call them mechanics liens, no carpentry work that was unpaid for, no septic system that was unpaid for. So if you have a choice to pass on a deed to your heirs, definitely do a general warranty deed. There are special warranty deeds as well. Margaret and I did a session that was on deeds and or on Landowner 101 with Roanoke Electric. And I noticed that there were a lot of special warranty deeds. And that special warranty deed is the person who sold it to you or transferred it to you said, you know, I didn't do anything to mess it up, but I don't know if there were problems with previous landowners. So special warranty deed is good, but general warranty deed is the best. Probably the most common thing that I saw is a quit claim deed, Q-U-I-T. It's not quick, it's quit. And people have passed heirs' property down with a quit claim deed. I know we have two lawyers on, Miss Pamela and Miss Mavis. So if there are any questions about that, they can answer. But what the previous owner is saying is, I'm making no guarantees. I'm just passing down to you what I have. There's been no lawyer who has reviewed any of the title work. Now, another one of you said that you had a gift deed, and a gift deed is the same as a quit claim deed. I see that in the chat box, we also have a non-warranty deed. And for a non-warranty deed or a deed prepared with title, without title examination, that means the deed was passed and there wasn't an attorney involved deciding, you know, who were the heirs. There are real estate attorneys, as Ms. Mavis said last night, who have a specialty in estates, who can help with those where property is informally passed down. So prepared without the examination or non-warranty deed is another type of deed. So when you look at a deed, there are two words, and I've never seen a deed without them. So there's grantor, and that's the person who's selling or giving the property, and grantee, and that's the person who's receiving the property. So you can figure out, well, who gave it to you, and who, if you're not the owner, who's the owner? We talked quite a bit about heirs' property last night, and I'd refer you back to that excellent presentation. If your name is not on the deed, I'm not going to go into depth because we talked about it last night, and that's a recorded presentation, but you need to bring your deed up to date. It's easier if there's just one heir. If there's more, I suggest you watch the presentation which Ms. Mavis Gregg did. So you also need to look at how the land is owned. You know, if you're a single person, Margaret and I are working in West Virginia. We had a woman come in with a deed and her name was completely different than the deed. And we called and said, well, you know, is this your land? And she said, oh yeah, I got married. And so she hadn't brought the deed up to date and put it in as marital property. So at times we have, unfortunately, one of the spouses dies, you know, particularly during COVID times, it's been awful. So you might have to bring the deed up to date because one of the spouses died, or if there's been a second marriage, that makes things much more sticky. And Ms. Pamela talked about estate planning and second marriages last night. So I refer you to that excellent presentation. One of the things that you need to check out, and you see this with a map of your property, does your deed give you the legal description to go all the way to the road, or are you landlocked? So usually a tax map can show you whether you go all the way to a public road or not. If you don't, you need to figure out how long you've been using that access. There's a program that you can download called Google Earth Pro. You have to put it on your laptop, and it goes back. There's a slider, and it can go back many years. I had one go back to the 1930s with the Google Earth maps. So you could slide back and see how many years that your property had been accessed through another person's property. Another way to get maps, if you have a landlocked property, is to go to the Natural Resources Conservation Service. Margaret is going to talk a little bit more about this. And they have imagery. They've been flying the country since the 1930s. It's usually $1 a map. So you could figure out with Google Earth how many years that access has been used, and then go back and pick up the maps from the Natural Resources Conservation Service. That is important because you want to document how many years that access has been used. So you can ask your neighbor to give you access to the property and offer to pay for a survey, pay for the preparation of a deed. So you hire a surveyor, get the description to a lawyer, and hopefully that'll be the end of it. But sometimes you have to hire a lawyer to fight for you for access. But last night, Ms. Mavis made the point that the more you can do ahead of time and not have a lawyer do it, kind of use your own time in putting together the maps is one of the things you can do to save money with a lawyer. So Ms. Mavis talked about heirs property that's land owned by multiple people, each of whom inherited their share. And I will just refer you to her excellent presentation. So now I'm going to switch to leases, and I'm going to check to see if there's anything in the chat before there's a question about what if it just says deed? Yep, it's still a deed. It has no one standing by it saying it's been reviewed by a lawyer. So that would probably be a non-warranty deed. It's still a deed. It would be better if you didn't pass it on to your heirs that way, but it's a completely legitimate deed. And I have seen quite a few of just deed in North Carolina. All right, I'm going to tell you a story now as I switch to leasing. And so you're involved in this story because you've got to tell me, from your perspective, was this a good move? So there's a man named Mr. Tom Bailey. His name is not the same name to protect him, but he told me that he had gone out and he had heirs property. So he and 4 other of his family members owned a piece of property. And Mr. Bailey had been, he really had been out of town. He was in Chicago. He lived near me. And then he moved home when he retired, and he went to the family property, and the renter was there. And he said to the renter, well, what can you use on the property? And the renter said, oh, I use everything. I use the tractor. I use the house. I use everything on the property. And Mr. Bailey said, well, what do you pay? And the renter said, well, whatever I feel like paying. it's no big deal. I mean, your brother gave me the right to be here. And Mr. Bailey kind of went away thinking, well, there is a lease. And the renter said, yeah, there's a handshake lease. So my question to you is, what would you have done differently if you were Mr. Bailey's family? Hearing this story, what's your reaction? You can put something in the chat. I don't see the chat coming up. So Mr. Perry, I might need help on this. Is there anything in the
Yeah,
chat?
Nothing so far.
Yeah, nothing
Okay,
so
thanks,
far.
Pamela.
So,
Okay, so what I was trying to get at, okay, we got one. All right. So leases have to be written in a signed document. That's right. So the problem here is that it was an informal lease. We call it a handshake lease. And really, you don't really know what you've really shook on. And certainly in heirs property, you have no idea what you had in that lease. So I'd really encourage you to think about doing a written lease. So an oral or a handshake lease is not enforceable. So if this renter of the Bailey family backs out, either way, either the renter or the Bailey family, nobody else has any rights. If one of the parties died, say Mr. Bailey's brother who did the lease, nobody knows what the terms are. The good thing is it's easy to do, but I would really encourage you to have a formal lease, and as in the chat, have signatures. Sometimes you want to go as far as to having it witnessed, but to have the terms clearly spelled out. And exactly, we have another comment in the chat to determine what rent, what's going to be rented. So I said, the renter said he used the house, he used the tractor, he used the barns, but you don't really know what was actually used by the renter. So there's a website that's really great. It's called Land for Good. And under the toolbox tab, you can build a lease. And I just did build the lease today or this week with someone in West Virginia. And it just worked amazingly well because it figures out everything you need to have in a lease, and a lease spits out at the end. You can also hire a lawyer to draft a lease as well. Either way is good. It just depends on how good you feel about your skills in drafting. But those are two ways to get a lease in North Carolina. So I'm a farmer and I've had to lease part of my land out. And before I did the leasing, I walked around with a person that I was going to rent to, and we talked all about what was going on. I really care about soil health. And I had another guy who was renting my property for hunting, so I didn't want to include that in the lease. But once a year, whether it's a new lease or I'm using an existing lease, I meet with that agricultural landowner and we talk through the terms just to get on the same page with one another. And we talk about what will really be leased. So it may be, so there's a question about, should the lease indicate if one is leasing or can sublease the property? Absolutely. I would really encourage you not to give the person who is the leasee the right to subcontract. I think that's something you should keep hold of, because otherwise you don't know whether that subcontractor is doing what you want done. So some of the things that you can consider are, is the farmland or timber or hunting or fishing being leased out? How do you reach the tenant? Had a total nightmare where one of the people who leased one of my properties left me DDT. And it turned out that barn became a Superfund site. And it was hundreds of thousands of dollars to clean it up. Luckily, I was able to get money for it, but you know, how chemicals are stored really make a difference. The other thing is I always have the tenant have insurance. And so you need liability insurance. We had the fellow who rented from me, he did a tractor roll and he was killed, which was awful for everybody involved, including him who was dead. So I just really encourage you to have some sort of liability insurance. Miss Mavis or Miss Pamela, there's a question in the chat, and I'm going to read it for you. I wondered if one of you could come in, since you know North Carolina law better than I do. The question is, there's a 20-year plus oral lease. Can it be terminated by one heir if remaining 3 heirs disagree? Would one of you want to take that question?
Hey, so if the property is owned by 4 individual people as tenants in common, so if there are 4 owners, which is what I'm understanding, there's 4 individual owners, you own it as tenants in common, which if you became owners through inheritance, then you own it as tenants in common, then it requires unanimous agreement. I am curious about a 20-year oral lease because, and you're taking me back to law school now, but certain contracts have to be written if the value is significant enough. And I can't remember, I'm trying to think of the terminology that I'm thinking of. But anyway, a 20-year oral lease, meaning there's no writing, is even more concerning than the question of whether someone can terminate it. But the answer is, to your question, no, it would require all owners.
Thank you so much. I appreciate that. Oh, I'm going to touch that one with a 10-foot pole. So, okay. So during that pre-lease property walk, you know, are the improvements used, the buildings, who pays for them, who owns them? My tenant put up a high tunnel. That high tunnel was his high tunnel, not my high tunnel. He used the barn and repaired the barn, but I specified what kind of repairs he did to that. I talked about, I'm concerned about soil health. So I required in my lease that he put in cover crop, you know, what's farmed, where is it farmed, and the fact that the tenant should take off the waste, whether it's chemical waste or, I mean, he was using plastic because he was growing tomatoes in large scale. I didn't want that tomato plastic waste left for me and my future generations. So you got to think about what you're doing and what you leave on the property. So if you, you should have terminology on what happens if you need to end the lease. There's a question about, should I ask the renter to show proof of insurance? It should be in the lease. You should have a copy and you should be named in their insurance. So it's good if you both use the same company for insurance. It makes it a lot easier. So yes, it should be in the lease, and you should be, if you can get on the same page with the same insurance company, it's good. So you also talk about, when I was talking about Mr. Bailey, he couldn't figure out whether it, what the rent was. You need to specify how the rent was done. Is it done on shares? Is it a fixed amount? What's permitted on the property? What happens to unharvested crops? I mean, right now we had a very early, late September fall or snowfall, and people haven't gotten their corn off yet. My lease says that guy has to have his corn off by January 15th. Well, I'm going to be a good person and let him get that crop off, but you have to specify how long it is to get the crop off. And also who pays for maintenance, who pays for repairs. And the question is, should the grantor, so it'd be the leaseor and the leasee, should they both have insurance? Absolutely. Yep. If you have anybody farming on your property, I would suggest that you have insurance. So when you draft a good lease, I like to have my natural resources conservation plan, and Margaret will talk a little bit about that, that they follow that plan, how the tenant should contact me, how often I do an inspection. And here it gets into the insurance that we already had a question about. So the lease should really specify how things are done. So this session is not to give any legal advice. You can see that I flip questions to Ms. Mavis. So I'm looking at the business aspects of it. I really encourage you to seek attorney help if you have any legal needs. You save so much time by having an attorney ahead of time rather than not using an attorney. So before I switch over to Margaret, I'd like to open it up for any questions that you might have. If there aren't any questions, I wonder, Miss Pamela, if you'll talk about the different ways that land is owned in West Virginia, or sorry, I'm in North Carolina. Sorry, my apologies. Joint tenancy, tenants in common, and just give us a broad idea about that.
Certainly. Hopefully everybody can hear me okay. The three common ways that land is owned is tenants by the entirety, joint tenants with right of survivorship, and tenants in common. And so tenants by the entirety is a special designation that's used only for married couples. And I also want to say, Mavis, if you want to jump in, that's fine, because Mavis did go over this last night, but we're just going to give you a brief refresher. So tenants by the entirety is only used with married couples, and it protects the spouses. So the purpose of it is if there's a judgment against one spouse, and let's say they own real property with tenants by the entirety, then the creditor that has that judgment against the one spouse cannot force the sale of that real property to pay off that judgment. And so it's protecting the other spouse. So that is a very good, that's the best way to own property. But you can't use tenants by the entirety if you're not married. So that's the only option for using that is to be married. However, if both spouses have a judgment against them or a joint judgment, then that protection is lost. So it's really there to protect if one spouse has a judgment. But if it's a joint judgment, then all bets are off, and the property can be, they can force the sale of the property to pay off the judgment. Now with joint tenants by right of survivorship or with right of survivorship, that is when both people own the property 100%. So you each own all of the property and have all of the rights to the property, but there's no protection. So if one person owns a share of the property, actually they could be forced to sell the other person to pay off the judgment of another. So that protection isn't there. But what is there is you are allowed to automatically own the property at the death of the other owners. So, but with tenants in common, so you get so going back to joint tenants with right of survivorship, no one else owns the property with you after that person dies. You are the 100% owner. But with tenants in common, when people own different shares, as they pass away, those shares do not fold into the other owners. Those shares go to their heirs. And this is how we end up with heir property. So when you own tenants in common, you have to will your share or put it in trust to another individual, because the survivors who own as tenants in common with you do not automatically get your share at your death. So those are the three ways. And obviously tenants by the entirety is the best, but you have to be married. And then the next best would be joint tenants with right of survivorship. So I don't know, Mavis, if you have any other comments about that, or if you wanted me to go into more detail, Peg.
No, that's good. You find this, oops, I'll get you in a second, Ms. Mavis. You find it on the deed by the name of the person. You can see whether there is one of these ownerships. So Ms. Mavis, do you want to, if you have any comments, and then I see in the chat, there's one made for you too, a chat. So.
No, I think Pamela covered it very well. I didn't hear the original question because I had to refill my water glass, but there is a question. So someone asked to repeat what tenants in common is. And then there's a question about one owner doing things on the property. So I'll answer the tenants in common question again. So there's different types, there's different categories of property ownership, and they have specific legal rights attached to them. So as Pamela was discussing, tenants by the entirety is a type of property ownership right that married couples have. Tenants in common is a type of ownership that heirs property owners have, and quite frankly, most folks who own property with multiple people, unless you specify in the deed document a different type of ownership, such as joint tenants with rights of survivorship. And so the rights that come along with it, Pamela has already expressed, so I won't repeat those, but it has to do with how you became owners and what rights are associated with that type of ownership. Another question that came up is, if heirs property is tenants in common, what is the most beneficial form? Would it be most beneficial to form an LLC structure? And that really just depends on a lot of factors. And then that's why it's important to work with an attorney to give you counsel, because it may be an LLC may be more difficult to manage than a trust, or it may be that an LLC offers other benefits that a trust doesn't. So it really does depend on the family, the land, and so forth. There's no model that fits everyone.
And one more point, thank you, Mavis. You automatically own land tenants in common in North Carolina if you don't specify that it's joint tenants with right of survivorship.
Oh, am I glad I didn't try that answer. So anyway. All right, thank you both. I really appreciate it. It's amazing how different the law is from state to state. So I would like to introduce my colleague, Margaret Conrad, and she will take over from here.
Hi, everybody. I'm so glad to be here with you all. I'm Margaret Conrad. I'm with the Conservation Fund's Resourceful Communities Program, And for 30 years, we've worked in rural communities, providing small grants, technical assistance, and networking opportunities. Our work is guided by a triple bottom line: conservation, sustainable economic benefit, and social justice. I hope you will become part of our network if you're not a part of our network already. Alton Perry is one of our long-term and esteemed partners. We're grateful for the Roanoke Electric Sustainable Forestry and Land Retention Project and the opportunity to work in partnership. Currently, Resourceful Communities is working on 2 USDA-funded initiatives to connect historically underserved landowners with resources and opportunities, and I hope you will keep and use my contact information. I'm talking with you today about using your land for additional income. Land is a form of wealth, a long-term asset. Preserving that wealth for the long term, though, can require income in the short term. The opportunities I'm talking about today will bring income that can help you offset cost of preserving your land assets, such as taxes. These are USDA programs, leasing for ag, hunting and recreation, and carbon. Please ask questions or offer your comments in the chat or at the end. And I'm going to ask Peg and Alton to help me with the chat, please. But one of our friends and mentors at Resourceful Communities, Yolanda Burwell, has a saying that the wisdom is in the room. I guess today we'd say the wisdom is in the Zoom. So please ask questions. And while I may not know the answer, I'll do my best to get you an answer. I'm starting with a program administered through USDA's Natural Resources Conservation Services called EQIP. I'm sorry for all these government programs have all these complicated names, but this one is EQIP. I encourage you to consider this if you are expanding your farming or undertaking forestry practices. EQIP can fund the majority, sometimes up to 90%, of what they call conservation practices. And those include reforestation and site preparation. And remember, as this is a government program funded by your tax dollars, so this belongs to you. So please explore it. Here are examples of what EQIP can fund and how these are considered conservation practices. They include fencing, high tunnels, organic practices, and site prep, planting, and forest stand improvements. Here's a breakdown of the process. What's important to take away are that you need to get a farm number to start and that you work with your local NRCS representative. For those of you in the Roanoke Electric area, the Sustainable Forestry Project will help you make that connection. For those of you outside the Roanoke area, Resourceful Communities is eager to help. Setting up these meetings with NRCS, which is short-staffed, takes time and persistence, so it's never too early to start the process. To get a farm number from Farm Services Administration, you need your Social Security number, your deed, and a completed average adjusted gross income form, which basically says that your farming proceeds under $1 million. Once that's done, you can proceed to apply for EQIP and other NRCS programs. I would strongly encourage all of you to get a farm number if you don't have one already. You can see here some of our partners with whom we've worked to get EQIP. On the left is Pastor Brian Wilson, who runs a church-based farm in Western North Carolina. In the center is Ms. Cheryl Austin, who has provided an abundance of needed fresh produce through the Little Washington Growing Group in their high tunnel. And on the right, you see property owner, Ms. LaTanya Andrews, who worked with NRCS to get a forest management plan to significantly increase her timber harvest over the long term. This is important to her as the parent of a young daughter that she intends to send to college. In addition, we explored annual income opportunities by leasing her land for hunting. I'll say a little bit more about that in the next slide. As Peg noted earlier, leasing your land is a great source of supplemental income. Many landowners lease their land for farming, but it's hard to know what a good lease looks like and information surrounding that lease. So I, like Peg, recommend that you look up Land for Good. That site, explore that site, not just for the lease prototype, but information about leasing for ag land. You'll be glad you did. We also work with a number of landowners who lease their land for recreation, particularly hunting, fishing, and camping. This is a good way to get income to defray the cost of land ownership, such as taxes. But it can be difficult to know what the going rate is for hunting and recreational leases, as well as the process. Two options I wanted to bring to your attention for learning more are Outdoor Access and Hunt NC. Outdoor Access is a company we work with that matches landowners and individuals interested in leasing land for hunting and recreation. It works like an Airbnb for hunting and land recreational leasing. I connected Miss Andrews, who you saw on a previous slide, with Outdoor Access. The business benefits of this are that it interfaces with the folks interested in leasing your land for hunting and manages the process. And it also provides a $4 million liability insurance coverage. Here's the website and information on Outdoor Access. Even if you decide not to pursue it, it's a good piece of information for the lease prices and the seasons. Another resource you should know about is Hunt NC Farmland through the North Carolina Department of Agriculture, which has a virtual bulletin board and resources page. Here are some options available on the Hunt NC Farmland. Landowners are also seeing income opportunities in carbon. A growing number of companies and organizations are buying carbon offsets from landowners that are produced by their trees and soil. They're called offsets because companies such as airlines purchase them to offset the carbon emissions of their businesses. Most of these opportunities are long-term commitments, 40 years for the so-called voluntary market and 100 years for the compliance market. However, there is at least one new company working with Microsoft that will lease your carbon annually. The return is less, but so is the commitment. These are rapidly evolving opportunities, so keep an eye on them. There are also federal proposals being considered in Washington to expand carbon offset opportunities for smaller landowners with greater involvement from USDA. This is all part of the growing recognition on the federal level that supporting improved conservation practices, including forest management and planting, can help landowners and the climate. In that regard, USDA's Conservation Stewardship Program is a great way to help the environment and provide you funding. Like EQIP, it is administered through your local Natural Resources Conservation Service office. Here's a little more about the Conservation Stewardship Program. It provides funding for conservation practices such as wildlife improvements and longleaf pine restoration. An advantage of longleaf pine, if you live in a place that can grow that, which are more sandy soils and warmer, is that the pine straw can be raked and sold, and that's another income opportunity. It's important to note that conservation stewardship programs are competitive and will take time. So it's like EQIP. You have to start the process early and work with NRCS. If you need help, please reach out to the Roanoke Center or to me. And here's my contact information. Thank you again for the honor of being with you today. You're all doing an important and sometimes difficult thing. You're building a long-term asset that not only benefits your families and communities, but also the planet. Thank you. And I'm going to turn it over for questions.
Quite a few questions there. I don't know if we want to go back from the start or.
Let's
Mr.
do it.
Perry? Yeah.
Yeah, go ahead.
Okay.
I answered some of them. You're welcome to read off what I said, but I did answer a couple of the questions.
Okay. So I can't see exactly which ones you did, Ms. Mavis. Would you go through which ones you did? Or which ones need to be answered that you didn't? So,
Okay. Yeah, one of the questions was if when married, if parties owned property as tenants by the entirety while they, so while they're married, but then get a divorce without changing the deed, but then one dies, where does the property, how is the property owned? I maybe answered that question differently. So let me correct myself. So if you own land with the spouse and you and the spouse get divorced, the ideal is to address ownership of the property in the divorce proceedings before the final divorce decree rather than continuing to own the property. But I recognize sometimes that kind of issue may not be resolved through a divorce. I'm familiar with people who continue to own property together even after the divorce, but ideally you would address it in the divorce. In this case, what it sounds like has happened is that the parties have divorced. If there is an actual divorce decree, that's significant. That divorce decree, so a court order of the divorce, it severs the the tenants by the entirety relationship, and you become owners as tenants in common. And so again, if you still own that property with the ex-spouse, when they die, you own it as tenants in common, and so their share went to their heirs. So it's possible in this scenario that the person owns the land with the heirs of the ex-spouse, which could be problematic. Another question is, what if there's an heir living on the property, there's no oral agreement or written agreement, and the other heirs want to enforce a rental agreement, but the person on the land is paying nothing and won't sign anything? It's common that you will have co-owners who usurp other owners' rights in the property, and they can't do that legally. So you could pursue court action to resolve that. I do recommend, though, that you first confirm who the owners are and how they became owners, so clear title. And then the owners who are getting along, who are working well together, it still makes sense for you to put your ownership into a single entity owner, because when you do introduce the property to the court system, you don't want to trigger the risk that the other owner will seek a partition sale and then the family lose the land. So if you already are set up where you have a majority of the ownership in an entity, that can offset the risk of loss of the property through a partition sale. But legally, no owner, if you have co-owners, legally, no owner can prevent the other owners from using the property. They can't use the property exclusively, so they do owe rent. The rent is offset by the proportion of their share, but it does make sense to get some data behind what you believe they should be paying and how much they haven't paid over the period that they've been living in it exclusively, and then perhaps consider court action. And then there was a question about a deed being in the name of the wife and perhaps that being a disadvantage, but I don't understand the question fully, so I'll ask that you just rewrite that question. And then that might be it. What if an heir won't sign a lease? Yeah, so if an heir won't sign a lease, they're not required to. So anytime you have problem co-owners, I think it's important to think about incentives they might appreciate to either cooperate or to stop being an owner. And sometimes it's the incentive is in the form of cash around Christmas time or around vacation time.
you're a land negotiator after my own heart. All right, it looks like there's a question for Margaret. What are the steps for my family to create a family forest, and what technical assistance and funding is available?
Well, I'm going to share that answer with Alton, but I would say that the first step is to make sure you have a management plan, and there are several avenues for getting one of those. if you you can do it. Well, first of all, wherever you live, if you're in the Roanoke district, I trust you have Alton's contact information. And if you're outside of the Roanoke area, I hope you have mine and we can spend more time on this. I would love to, either of us would love to speak with you, but you need to get that forest management plan will be the first step. And then from that will flow access to resources. I'm gonna turn it over to Alton, but before I do, I want to say that everyone, all the panelists on this call have been helpful in something that we're working on with our partner organizations, including the Sustainable Forestry, to set up a website that will have a roadmap for just to answer exactly this question. And it'll be launched within a month and it'll take you through these steps. So I'm looking forward to sharing that with you all. Alton, what did I leave out?
Oh, you good, Margaret. So those steps really is connecting with, if you're in our project area, connecting with us. If you're outside, connecting with Margaret. And I'm going to put a website in the chat here in a second. If you're out of state, if you're in Virginia, South Carolina, Georgia, Alabama, Mississippi, Arkansas, Texas, there is a network of sustainable forestry and land retention projects that are in this space assisting landowners. And if you're in another state, you can also connect with that local or that state sustainable forestry and land retention project site to receive assistance too. So yeah, the first thing, as Margaret mentioned, is connecting with resources. And I know it oftentimes, because of you may have not attended or an event like we have today, you don't know what those resources are. So all of us here try to find ways that we can get this information into the community, you know, be it via, you know, community leaders, community organizations. So first of all, trying to find out, where do I go to get resources? So once you come in and get those resources, the very first thing, whether it's agriculture or forestry, the very first thing you want to find out is, what are your assets as far as natural resources? And with forestry, that first thing that you want to get is the forest management plan. And then what our project does, we'll walk you through that entire process and how to get a management plan, how to implement practices in the management plan, what funding resources are out there, whether it's through the Natural Resource Conservation Service, whether it's through the North Carolina Forest Service. And so we walk with you through all of that. And also we look at addressing those issues that have been touched on here today about estate planning and air property. So being a part of our project will provide you this opportunity of guidance and information to move forward in land retention and resource management.
Just unbelievable to have it in North Carolina. There's no other place I know that has anything like it. So,
the only thing the only thing I would add is the only mistake you can make is to do nothing, because it's so because trees are it takes them a while to grow. So instead of don't let the grass grow under your feet, I'd say don't let the trees grow under your feet while waiting to get started.
There are, Margaret, if I can also expand on one thing I'll talk about in a second, but there was a question about carbon, and I'm not sure, well, I am sure Bob is still on. It all depends on, I think the question about the number of acres you needed to participate in a carbon program. I do know in some cases that acreage can be relatively large, you know, anywhere from 1,000 to 5,000 acres. But there is work being done to how do small landowners get into this market as well. And one of the ways that that can happen is called what they call aggregation. That is, if let's say you have a locale that has several landowners who are interested. When all those landowners put their acreages together, still own them individually, of course, but when they put their acreages together, then they can look at opportunities of entering this market. Carbon markets are changing, developing. So one of the things that we're going to be doing is keeping our eye on it and to ensure that we provide you as landowners the information and education to put you in a position. So when those opportunities come and are available, that the question would be that you are ready. The question would be if it's something that you want to pursue or not.
Yeah, it is changing so fast, but I do think they're trying to open it up more to the smaller landowner. The opportunity that I know of right now is that Sylvia Terra, and I don't know much about it. They've just rolled it out, but it is for smaller, for smaller holdings, but there is a size that it's not, that's not worth, you don't get enough return. But so I do think the time right now is to watch it, learn about it. And I think that the opportunities for small landowners will continue to grow. There's some now and there'll be more later.
Okay. I see a question there about, are there consulting foresters that you would recommend for working with minority landowners who have land with trees? So I think working with a consulting forester is something that we recommend. Being able to get value for your timber, the current value as opposed to pennies or opposed to penny on the dollar. We recommend that. What you look for is, what we recommend is you talk with at least three consulting foresters who are in your area. And when I say in your area, typically, unless you have some very high value timber, consultants are probably not going to go, outside of an hour drive, maybe 50 miles, something like that outside of their where they live to work on a tract. So there are many consultants across the area. We can assist you on identifying, several in the area. There's lists. That list can be obtained from the North Carolina Forest Service, but also we'll be glad to work with you on providing that list and helping you navigate through consultants that can provide assistance to you, because consultants do more than just sell timber. They can do an array of different natural resource management, whether it's wildlife management, hardwood management, pond management, recreation, and the list goes on. So connecting with that natural resource professional is so important, and consulting foresters is so important, and understanding the difference between consulting foresters, timber buyers, timber companies, and loggers. So all of those are in that forest industry. And as a landowner, it can get confusing. Timber sales are very complex. You only sell timber maybe once, maybe now with the market the way it is, maybe twice in a lifetime. But once those trees are on the truck and leaving the forest, you cannot do anything to kind of recoup any value that you did not get from the timber sale. So it's so important that you do all that up front.
I
We
think,
had Peg, did you see the question from Miss Perry?
was it about okay, let me go up. So Miss Perry says that she says that there's specific grants available for minority females if the property is owned solely by the woman. So I just don't know about this. Mr. Perry, do you know?
So there are not any, I won't say not, I'm not aware of grants that are for solely female. However, in USDA, if you are socially disadvantaged or historically underserved representative, that is, if you are African American, Native American, Asian, Pacific Islander, Latino, those are the socially disadvantaged categories that USDA operates under. And so if you are applying, as Margaret talked about, the EQIP program or the Conservation Stewardship program, then you can be placed in those pools that are specifically for those categories, including veterans. There are a lot of programs out there through USDA for veterans, not only in agriculture and forestry, but other things as well. So yes, not so much for women, but if you are a woman of color or within those socially disadvantaged categories, yes.
And I think Ms. Perry went on to ask though, if you take advantage of some specific funding or grant opportunities and your situation changes, she said there's concern to make sure that the husband has no problem with the ownership of this property at the death of the wife. If the husband's name is now placed on the deed, does that no longer make the property qualified for the grants? So the question is,
right. So right. That goes really back to what you originally talked about, Margaret, on having that farm and tract number.
Mm-hmm.
So when you're working with USDA programs, and you talked about the EQIP program, which is actually administered through the Natural Resources Conservation Service. So to actually apply for that EQIP contract, you actually have to go to Farm Service Agency to get your eligibility paperwork in order.
Mm-hmm.
And that includes getting a farm and tract number. Now, if you have a property that is both ag land and forest land, and you farmed it or you're leasing it, more than likely you already have a farm and tract number. And then all you do then is, make the application. If anything changes as far as a death in the family, you need to get to Farm Service Agency and get your eligibility paperwork updated. Because if not, that is going to be an issue down the road when someone else comes in and wants to say that, we want to apply for something. And that paperwork has not been updated. There's people on the eligibility or has control to have authority to sign, and that person is no longer living. And just talk with your Farm Service Agency. They will instruct you on what documents you need to bring in to get that paperwork updated. It may be a death certificate or a deed or something else, but you want to make sure that you get the FSA to get your eligibility paperwork updated. We see that so much when in our project, when we're working with landowners, that their FSA paperwork has been outdated for years. And it can really be a challenge and a hindrance on moving forward.
All right.
And there was a question here from Michael Dukes about that relates to what you just said, Alton. Can you have your timber cut and still participate in conservation stewardship programs? And that ties back to it's an arrangement, it's a contract. So you can still practice forest management, but you'll need to abide by the agreement which would be probably reduced harvesting or a different conservation practice. The carbon's going to be the same way. Any of these are going to be an agreement that you need to do something for conservation, and in turn you'll be compensated for that. Right. Alton and Peg, add please to that.
Yeah, on the timber harvest, once the timber is harvested, the process is, if you are working with a consultant forester, the consultant forester, talk with them to determine if they're going to assist you on moving forward with the timber sale. The timber sale and the reforestation. They can be separate. You can have a consultant forester just do the timber sale for you to manage all that. And then once the timber is harvested, depending on what state you're in, if you're in North Carolina, you can contact your local North Carolina Forest Service in your county. If you're in other states, they may be either on a county or regional basis, but they can be the next step on accessing your harvested area and what the recommendations are needed to implement reforestation. Then once you have that reforestation plan, you can now go to the Natural Resource Conservation Service. Your state agency may have a cost share program as well that you can apply for. Also, a caveat is when you apply for reforestation or any type of management practices, you can apply several different ways or different areas. You can apply with the federal USDA or the state, but you can only select one if you're approved for both, okay? And so now you can move forward, and each program has its different guidelines. So that's why it's so important that you sit down with your conservation, your district conservationist or your North Carolina Forest Service county ranger or forester, and really have them, explain to you what your responsibilities are. Because as a landowner, you have responsibilities because you are under contract with the USDA Department of Agriculture or the Forest Service. So you want to make sure you are following the guidelines, meeting the recommendations in the plan. And that's what those natural resource professionals in your county are there for, to assist you. If you're a part of our project, you can always come to us. We're going to be walking with you through that process to ensure that you know the steps to take to have a successful natural resource management engagement. So, yeah.
Since you're on that topic, there's a question about how much a consultant forester would cost. Maybe you can kind of take that, and then there's another one. So if you want to take that question.
Sure. So consulting foresters, also know that consulting foresters, they have registration numbers. Let me also provide that information. So if someone is calling themselves a forester in the state of North Carolina, they have to file or pass a registration examination, and they are provided a number. They have a registration number. So if someone says that I'm a registered forester or I'm a consulting forester, you can ask them for their registration number. On the list that they are located on the Forest Service webpage, their name and also all the different services they provide are there, but also there's a registration number. So when you inquire the services of a consulting forester, they can do a couple of things. If you want them just to appraise your timber, what value you have, they can do that for a set fee. They'll come out and work on it and say, this is my invoice. It could be $500, it could be $1,000. The other thing that they can do is that they can do the appraisal, but they will also, you contract them to do the actual timber sale. That is, they identify the property lines. They identify environmental issues, like if there's a stream involved, how to implement water quality regulations and guidelines through the timber operation. They do all that. They check on the harvesting when it's going on to make sure it's going correctly. So when they do that, they will do what is a commission fee, just like a real estate agent. That commission fee, depending on where they are, could range anywhere from as little as 5% to as much as 10%. And so, that's how they are paid as you hire them or when you hire them to provide that assistance to you.
There's also a question about grants to nonprofits.
I'll take.
And you want to take that one? Okay.
So that is exciting to know that they, yes, there are. And in my presentation, I had a photo of Ms. Cheryl Alston, and she had the High Tunnel House. Hers is a nonprofit. And so, yes, you can apply for funding, equip funding as a nonprofit or as a church. And that's been an exciting improvement. Thank you.
Yeah.
There's a place that's called grants.gov. And under grants.gov, you can toggle through and look at which grants are for nonprofits. And there are a variety of grants as well as these that are in the natural resources features. So there are 3 questions in the
Mhm.
Q&A. Okay.
All righty. There's one about, dividing the property up. So that's a good question. So when a forest management plan is done, foresters typically divide the property up into stands or areas, specifically if they are different. So they can be delineated. So for instance, if you, and I just used a random number, let's say you've got 50 acres, and if you've got 25 acres that is loblolly pine that's 10 years old. You have 15 acres that's longleaf pine that's 25 to 40 years old, and you may have a hardwood stand. So that forester is going to delineate all of those areas in the plan. And when you look at the map is going to show you area 1, and it'll have a description. Area 2 will have a description. Area 3 will have a description. And each area will have its own set of recommendations. So for instance, let's say, for instance, that you wanted to do a herbicide application on the longleaf stand for some reason. So that management plan can be taken to the Forest Service. It can be taken to the Natural Resource Conservation Service and said that area 2, which is 20 acres, and we want to do a herbicide release, or we want to do a prescribed burn. Let's say prescribed burn instead of herbicide release. And so now when that is being applied for, the district conservation knows exactly what area you're looking at and what number of acres that this application would be put on.
Good. There's another question that's being answered in the chat. And Ms. Mavis is answering it. The question is, so you're saying that cooperating owners can form an LLC without the non-cooperating owners. So we'll wait to see her answer to that in the chat. Or do you want to answer that, Ms. Mavis?
Yeah, I can. So ideally, all of the ownership is put into the entity owner. However, sometimes that's not possible. Sometimes you don't have agreement by all of the owners to do that, but individual owners can transfer their share into the trust or LLC. That doesn't require unanimous agreement. And the reason why you would want to consider that instead of waiting until you have all owners on board is that you want to offset the risks that any owner will seek a partition action. Typically what happens is uninterested owners or owners who aren't cooperative will transfer their shares to a third party who is interested in acquiring the land. And the third party wants the land because they want to use the legal right to force the sale of it so that they can purchase it at auction. And so by you putting as many shares into the single entity owner, it's making a larger fraction or a larger proportion of the property being held by the single entity owner. So when the clerk is looking at whether the property should be sold, they first have to consider, can it be physically divided? And so having that larger proportion in there can make that more probable that they will consider division over a partition sale. Hopefully that makes sense. But to give you an example, I had a family where there were 72 owners and I think maybe 90 acres, I can't remember, but there were 72 owners and 2 of them sold their shares to the neighboring farm, who then proceeded with a partition for sale action. And their claim was successful because they said, there are this many different owners with different proportions of ownership in the property. Well, if you had most of those owners on board with transferring their shares into the single entity owner, then the acreage probably could be physically divided, and that third party commercial farm that was interested in retaining or getting the whole property would actually likely lose interest because they're not able to do that. They're only going to get whatever their proportional share is. So yeah, it's definitely worth considering.
So Bob, would you come on, please, and address the question? There's somebody who wants to have the resources in the chat and wondering if they would be emailed out. Would you respond to that, please?
Yeah, so I will, Alton, you'll get an email with all these links that I've been posting in the chat with resources to the publications. And for many of you, if you go to your cooperative extension service within your state, most of them will probably have forestry and natural resource programs with publications that are related to many of the topics you talked about today. That would be a good resource to start with for finding things more specific to your area. But we will share the ones in the chat today. Alton, I will send you that list and you can share it with the participants.
Okay, thanks, Bob. Yeah, it's important that you can sign up for e-newsletters from Cooperative Extension, from NRCS, from Farm Service Agency, to be updated on, what's happening with the different agencies and also workshops. They're on Extension Forestry's website to keep you updated there to know a webinar is coming up. So it's a good resource to have right there on your phone or on your computer, getting those emails, those notifications. Okay.
Somebody asked, we need to answer, Mavis, thank you, noted that we hadn't answered the technical assistance question.
Okay, I'm not seeing that one. What is that question?
So it says, what are the steps for my family to create a family forest and what technical assistance and funding is available?
Okay. Yeah, so again, if it's a property within the Roanoke area, come see us, talk with us. So again, the first step is obtaining a forest management plan. And forest management plan is obtained through a couple of ways. One way is through your local county, North Carolina. If you're in North Carolina, your North Carolina Forest Service. If you're in another state, it may go by the Forest Commission or something like that. They will assist on developing a plan. North Carolina Forest Service now does cost, there is a cost to develop that forest management plan. It is $5 per wooded acre. So the technical assistance part is that Forest Service going out to your property, walking the property and identifying what trees you have, how well they're growing, how large they are, how tall they are, what kind of soil you have, addressing if there's a stream on it, if they see any type of insect disease, storm damage, just really giving you a good overall assessment of what's on the ground there. Then also providing some recommendations based on your objectives. The forester or any forester is going to always ask the landowner, well, what are your objectives for this land? Is it timber production? Is it wildlife? Is it recreation or anything like that? So you have to give them some idea of what you think you want to do. And then they're going to cater that plan towards reaching your objectives. And then once that plan is done, then if there's opportunities for cost share to implement a practice, as I mentioned before, could be prescribed burning, it could be planting or reseeding of new trees, it could be the site preparation that's needed to plant new trees. So all those types of practices would be eligible to look at cost share either through state or through the Natural Resources Conservation Service.
And outside of the Roanoke Center area, the Conservation Funds Resourceful Communities Program will be happy to help you. And then also, as Alton, you mentioned the network in other states as well, the Sustainable Land Retention Network in South Carolina, Center for Heirs Property, and Georgia MAXI. There are a lot of resources that span the region.
Right, right.
And a thing to remember, if it's not one of the ones we talked about today, check with your local extension office, or check with your local Natural Resource Conservation Service office, or your state agency also often have local county offices that you can check with that can point you to these different resources for assistance.
Right. And you can also throw into that mix of different agencies. If you have your Department of Agriculture, you can also connect with them to find other resources as well. One thing we didn't talk about much as it relates to air property, and Margaret talked about getting a farm and tract number. So what if you have air property and you want to get a farm and tract number through FSA? There have been some changes where even if it is air property, you can obtain a farm and tract number. It is in the 2018 Farm Bill. There are certain documentations that can be provided to say that you are a co-owner or have control of the property. And there is a fact sheet that we can put in, and we can send everybody to about that. But it is important to know if you go to FSA or NRCS and you say, I have heirs property, and they say you're not eligible, don't turn around and walk out the door.
Right.
Say, let's see, how we can really determine that I'm not eligible. And so, yeah, so if you got heirs property, there are opportunities that you can participate in USDA programs. One of the things that Mavis talked about last night was the Uniform Partition of Heirs Property Act, which in the Farm Bill mentions that if a state has that enacted, these are some of the guidelines. Like Mavis has mentioned, unfortunately, North Carolina has not enacted it yet, but there is movement afoot, if you will, to see if that can be changed or get that introduced into the 2021 long session, to see if we can get that moved forward.
I would just reiterate what you said, Mr. Perry, is I guess in some offices, there is just plain racial discrimination. And if that happens to you, certainly stay there, but reach out to Margaret in North Carolina. We have partners in most of the southern states who can help. I work in West Virginia, and we don't take that. That's not acceptable behavior. So get someone to come alongside of you. And if you need to bump it up, we had to bump it to Washington on one of them because of just blatant discrimination. So don't let that happen to you. Get help right away.
Yeah, and there is an official process through their civil rights section to with discrimination. So there are avenues that you can take if you feel like you've been discriminated against in any USDA program or service area. I do see a question there. Would my forestry consultant assist me with the cost sharing program? Yes, he can or she can. Your consultant can, like as I said before, can handle as much as you want them to. If they are administrating the forest management, and also that can include the cost share. They can get you the cost share programs and cost share application. You sign them, and they can handle that as well. Yeah, sure can. Good. So have we cleared up everything in the chat? Here's another one. With the property finance has been a burden that's spread amongst the family, are there any free ways to obtain legal guidance for estate planning or wills? Mavis and Pamela, I'll let you answer that first, and then I'll provide some additional comments on that.
I think that's a great question. I think that it can feel overwhelming from multiple perspectives, including financially. And so it's important to understand what you are financially capable of and what your co-owners are capable of. If and what the goals are. So if the goal is to clear title, like if you need to confirm the legal owners, that process can take, that can be costly. And so perhaps instead instead of engaging in the full process, perhaps you're first asking, first building a comprehensive family tree, which costs less than having an attorney do it for you, but then also having an attorney do some initial work. You and the attorney identify the benchmark where they're going to stop, and then check in with you about what the progress is and how likely it is that they're able to accomplish the goal. With respect to estate planning or will, typically the free services are basic services, and creating a basic will for family property that you want to stay in the family for multiple generations is not going to support the goal. And so it makes sense to instead try to develop funds or crowdsource funds to achieve the goals that you have, whether it's planning or resolving the heirs property title issues. Pamela, I don't know if you have other thoughts on that.
No, what you mentioned is good. The thought is everything has a cost to it, unfortunately. And what you want to think about is down the road, because Mavis and I work in the area of helping people set up their estate plans, but then we also see what happens on the other end when it's time for estate administration after someone passes away. And I can tell you that even though it seems like estate planning is an expensive ordeal to undertake, it's much better to pay up front, because at some point you're going to pay. And on the back end, it's much more expensive. So even to administer a small estate can be as much as $5,000, and most estate administrations are somewhere between $10,000 and $14,000 and $20,000. And then if they're complicated, it's even more than that. So you think that it's expensive to do an estate plan, but it's much more expensive to have a mess on the back end. So that's something to really think about, and maybe family members can pool resources to get this done, because there really isn't a way around the cost.
Yeah, and I'll just add to that. All of these sites, the sustainable forestry, land retention sites, are looking at ways to reduce those costs or defray those costs, whether it's through, working through clinics, the local, law universities, or finding some outside resources, financial resources that they can provide some cost share to legal services to landowners. So we've done that. We are looking for funds to assist landowners on their legal services. So if you are within the project area here at Roanoke, and you meet our guidelines, and our guidelines are, one, you be in one of 7 counties, and that's on our website. And also you have at least one area of woods land that is 8 acres in size. And so being a part of our program does provide some benefits financially, where if the project has funds, we will look at ways to assist the landowner, either from a forest management standpoint and also from a legal standpoint. Bob, I'm going to ask you to do me a favor. Can you put or add the link to the present use in that list of links you're going to provide to me? We didn't talk about present use, but that is something that's important here in North Carolina, and there may be other states too that may have present use. That is, landowners can get reduced taxes or deferred taxation based on the way that land is being used, either through forestry or through agriculture and also horticulture. There are guidelines that you must meet. In forestry, you have to have at least 20 acres here in North Carolina 20 acres of woodland in one area. And then you also have a forest management plan on those woodlands, on producing timber, producing income. So that is a way that landowners can look at getting a reduced in taxes. Also, we've seen across our project area anywhere from 40 to 50, and even some cases 60% reduction in taxation because they're in forestry present use.
It's also a question about the links from last night's links that were in the chat, and I'm assuming that they will also be brought over, that Alton will have those to send out. Is that right, Bob?
So yeah, we will make sure that people get those.
And we appreciate everybody spending part of their day with us.
Very much so. Thank you. Great questions.
Yep, definitely. Thank you to all of our presenters and to, Extension Forestry for their support on our platform here. And just if there's one thing that you may have picked up on these two sessions, that this work has been done because of partnerships, partnership between state and private organizations. And so, we do this to assist you, to get you informed, and to empower you that you can take that land out there and make it work for you, that you are a part of the economic, environmental, and in social. I think it's so important that you realize that you are a part of a global connection. You may not know that, but you are from an economic standpoint and from a natural resource standpoint. So thank you all for participating. Again, thank Pamela, Mavis, Peg, Margaret, Bob, and everyone behind the scenes and putting this together and having it being success. And also thank you for those of you who have attended, for your great questions and your eagerness to learn more about the conservation world and about estate planning and making sure that land retains or maintains in your family for years to come, and working through those sometimes difficult, but there are opportunities where if you stay with it, you can get some of those resolved. So there is hope. So let's see, also Bob mentioned, make sure you take the survey before you leave. That is so important, so we can report that information to our funders, but also you telling us what you need to make our services better to you, okay? Someone said, I tried to take the survey for today and a message returns saying that I had already taken the survey, okay?
Give me a second. Let's see what that problem is. Okay, they should be able to now.
Okay. Yeah. Well, thank you. Definitely we were glad we have encouraged you, and that makes us feel good that we're doing what we're supposed to be doing to encourage you and empower you to move forward. They say that knowledge is power, and I do believe that. However, we can talk to you all day long, but if you don't enact that knowledge, it's not really power. Until you put it in action and go out and start moving forward to work towards your family goals, that's when that knowledge really starts to become powerful, okay? And also share. Make sure we can't do this without you. Please share with your friends, your neighbors, your community, in-state, out-of-state, it doesn't matter. Please share, because that we know we are only hitting the tip of the iceberg on connecting with landowners out there who have forest land or ag land, or have heirs property, or don't have heirs property, but not taking full advantage of the technical resources and professionals and organizations that are out there. So please, by all means, share this information. Okay. If there are not any more questions in the chat, I think we are good. Okay. Well, again, thank everyone for joining us. The links to this to our sessions, both sessions will be on our website, but we'll also send those out to you who have registered as well. So to make sure everybody is know where everything is. So thank you. We're so glad we could help you out. Stay safe out there.
Bye-bye. Thank you.
Great job, ladies and gentlemen.
Thanks.